This is Court Watch with Alex Sawyer, and I'm excited to bring you the second episode of my podcast, where we will be talking about the Supreme Court's first week back in session this month and previewing the major affirmative action case coming up on October 31st. For any of you not familiar with the High Court schedule, the justices launched their 2022 term last week, hearing a much-watched case out of Alabama involving the Voting Rights Act. A lower court told Alabama it had to have 2 majority black congressional districts rather than just 1. But the state is charging that would require it to take race into account, creating a conflict between the Voting Rights Act and the Constitution. Race is also the topic in 2 affirmative action cases coming before the justices in just about 2 weeks. Here to break it all down with us is Carolyn Shapiro, an associate dean at Chicago-Kent College of Law and founder of the Institute on the Supreme Court of the United States. She served as Illinois Solicitor General from 2014 to 2016, and also previously clerked for Justice Stephen Breyer, who just retired from the Supreme Court this summer. She's an expert on the inner workings of the High Court. Hi, Professor Shapiro. Thank you for joining my podcast. As we sit here today after the first week's arguments, I thought I'd first ask you what you thought of Justice Jackson, since it was her first time officially taking the bench. I noticed that she was the most vocal justice actually during this past week's arguments. I looked at the word count, and I actually compared it to Justice Gorsuch and Kavanaugh and Barrett's first arguments. I've been covering the court since 2017 and somehow have covered 4 new justices. It's kind of crazy. But she spoke more than they did. And it was kind of my experience with new justices. I don't want to say they're timid, but they usually let the senior justices take control. I just thought, what was your reaction to what you heard from her?
Well, I was also a little bit, I don't know, surprised is the right word, but it was notable just how vocal she was from the get-go. And it's true that in general, justices tend to be a little more quiet at the beginning, although that was not true of Justice Gorsuch when he started, for which he was actually criticized by some people. I think Justice Jackson did not. It seemed to me she waited to ask her questions, although I didn't listen to all of the arguments. So that may have contributed to some people's sense that although she talked a lot, she was somewhat more deferential. But she clearly established herself as incredibly well prepared, incredibly thoughtful, and really willing to stake out positions that are not otherwise being articulated from the bench. So yeah. I thought it was pretty fascinating.
And I know you previously clerked for Justice Breyer, and his voice, I remember whenever I would be in the courtroom and he would ask questions of the lawyers, I always thought, oh no, here's a hypothetical I'm going to have a hard time following, like I was back in law school. And so it just kind of seems fitting that she took his seat essentially because her questions also were lengthy. It just seems like it was almost like a similar style.
Well, I wouldn't agree with that, actually. They were lengthy, or at least some of them were, and certainly in particular in the Voting Rights Act case. But it was a very different style. Justice Breyer was sort of known for his somewhat confusing, somewhat rambling hypotheticals.
Yes, definitely confusing for me.
Sort of a bit of a joke among some folks. And I always, because I clerked for Justice Breyer, I often felt a little defensive of him on this point. I think he always was trying very hard to articulate what he thought were the hard questions about the case and to let the lawyers know what was bothering him, essentially. But he was not particularly succinct, I think it's fair to say, or artful in the way he did it. And Justice Jackson, although she said a lot of things in her questions, was very clear and extremely precise about the kinds of things. There was nothing confusing about what she said.
Right. I know you mentioned the voting rights case. It's last Tuesday, they heard the challenge brought by Alabama after the lower court had told the state it should have had, correct me if I'm wrong in any of this, but I believe it was 2 majority black districts following the 2020 census. And at issue is part of the Voting Rights Act. I found it hard, actually, to tell where the different conservative members of the court were standing on this case. Sometimes during arguments, I can kind of pinpoint different positions. At one, I think it was even Justice Alito at one point said the state's argument was, quote, far-reaching. What did you make of the oral arguments, and do you have a guess about what direction the Supreme Court might be leaning?
I agree that the conservative justices did not seem prepared to embrace Alabama's most adventurous arguments. And so just to give a little bit of background about what was happening in this case, Alabama has 7 congressional districts until 1992. From Reconstruction until 1992, it never had an African-American member of Congress. It never had a majority African-American congressional district. In 1992, when there was a lawsuit a Voting Rights Act lawsuit that led to the creation of a single majority African-American district in Alabama, and there has been one and only one ever since. During that time, the last 30 years, the population of Alabama has changed. It is less white. It is more African-American. And it is in part for that reason and for other reasons related to demographics, related to where people live, that the Voting Rights Act lawsuit was brought alleging that Alabama was not allowing African Americans the equal opportunity to elect representatives of their choice as white voters. And the district court in Alabama that agreed with that wrote over 200 pages of opinion, engaged with the facts at an incredibly granular level. This was a panel with 2 Trump appointees on it. It was a district court, but there were 3 judges because that's special for certain types of voting cases. And it did not draw a new map. They sent it back to the legislature to try to draw a new map that would, if not create a second majority-minority district, at least create a district in addition to the majority African-American district, another district in which it would be realistic for African Americans in coalition with other voters to elect the representatives of their choice. So that's what the case is about. The Supreme Court stayed that order, and so the 2022 elections are taking place under a map that the district court said was illegal. So Alabama comes to the Supreme Court and says a couple of things that are pretty far-reaching. One was that in order to establish a Voting Rights Act violation, the plaintiffs should be able to come in and show that that they can draw a map, a second majority-minority district without reference to race in thinking about how to draw the district lines. That sounds very technical, but there are many, many factors that go into deciding how to draw district lines, and race is one of them. It's one of them because of the Voting Rights Act. And the Alabama is essentially asking for the Voting Rights Act to become a race-neutral law, which frankly doesn't make any sense. I don't know how to put it. It is a statute about race that was based on enforcement of a constitutional amendment that is about race. That was the 15th Amendment that was enacted because African Americans were not being given an opportunity to participate equally in the political process. The Alabama's even more far-reaching argument was to say that if that wasn't the interpretation, that Section 2 of the Voting Rights Act, the provision at issue, should just be declared unconstitutional. So I don't think I agree with you. It's hard to know what the conservative justices thought. I agree with you that it doesn't seem overwhelmingly likely that they are going to do everything Alabama asked for, but I'm not at all confident that they will affirm the district court, which is what,
well,
frankly, I think they should do.
Also, I guess the fact that they've let the map remain for the 2022 midterms, should we read anything into that?
Normally I might say yes, because ordinarily granting a stay is supposed to be based on a prediction about the likelihood of success on the merits. But in this instance, we have at least one justice who voted for the stay, Justice Kavanaugh, who said, well, I don't know that that's what the reason for this stay. He said, I think that the standards in the context of election voting cases is different from the standard for a stay in other contexts. And he relied on a case called Purcell, which says that courts shouldn't make changes in election and voting laws too close to an election. Now, he was roundly criticized, and in my view, correctly criticized, because this was months before an election, and it would have been quite possible to make the necessary changes without creating voter confusion or making things difficult for the election administrators. But that he was very clear that he had not made up his mind about the merits. So and Chief Justice Roberts actually dissented from the stay. On the other hand, he dissented from the stay only on procedural grounds, and he has never been a friend of the Voting Rights Act. So it's hard to read a lot into the stay at this point.
Okay, yeah, trying to like the arguments. I guess maybe it's based on what you're saying, it might be fair to think the court might come down for Alabama, but very narrowly. Is that kind of what I'm gathering?
I mean, that seems somewhat likely. I should add, though, I mean, I filed a brief in this case on behalf of Representative Sewell, who's the one African-American representative from Alabama,
right, and
some other members of the Congressional Black Caucus. And one of the things we argued, and this came out in the oral arguments as well, is that the Alabama's reading of the Voting Rights Act would basically, had that been the understanding of the Voting Rights Act all along, would mean there would be no African-American district in Alabama, in a state that is 27% African-American. So it's a reading of the Voting Rights Act that would truly undermine our efforts to have a meaningful multiracial democracy, and to recognize that the things that make it difficult for African Americans to participate, that make it possible for lines to be drawn that sort of essentially shut them out, has to do with things that have been in the law. So it's a self-perpetuating problem. It's things like housing discrimination, which was the law for decades. Just by way of one single example, education, segregated education. So all of those things have led to a situation where African Americans are, particularly in Alabama, less well off, less well educated, et cetera, and live in different places from white people.
And like on the same topic of race and racial discrimination, I thought you brought up education. That's a good segue to our next topic, which I asked you if you would preview the affirmative action cases, because I know on October 31st, that's the ones I've kind of seemed to get the most questions about, like from readers. It seems like that's the one people are focusing on the most, at least so far, in terms of the cases that have been taken up. I guess it's Students for Fair Admissions has challenged Harvard and the University of North Carolina's admission standards, using race as a factor for student applications. I understand Justice Jackson is recusing from the Harvard case since she sat on the Board of Governors, but she will be hearing and taking part in the UNC case. Do you think that will have any impact on the outcomes, or what should we be looking for during these arguments?
Justice Jackson was very explicit during the Voting Rights Act case in talking about the fact that the framers of the 14th and 15th Amendments themselves were not race neutral. They were very conscious of the need to do things to aid the freed slaves who were not white. And so she really took a head-on attack on the notion that the Constitution is colorblind in the way that many people, in particular many conservatives, argue. And that's going to be central to both of these cases. She'll be able to make the argument in the UNC case. I think it is unlikely to prevail on this particular court, although I don't know for sure. I don't know where everybody stands on these issues. And if with her vote there is a majority to uphold some form of race-conscious admissions in the UNC case, there will be a way that will be reflected in the Harvard case as well. And just to if I can give it just a little bit of context, for decades the Supreme Court has said that some race consciousness in admissions is permissible as long as it is part of a holistic evaluation of the applicants, and that it is not simply providing a plus, sort of a numerical plus factor for people who are racial minorities or quotas for numbers of people who are racial minorities, that it has to be a more holistic attempt to create a diverse class of students. And that's consistently been the law. There have been changes to how much race consciousness, exactly how it can look. That's been the law since the 1970s. What the plaintiffs in these two cases are asking for is to completely eliminate consideration of race at all when admissions officers are trying to decide who to let in, and that could very much change the population of students at many schools.
Right. So they're arguing that the policies are discriminatory against Asian Americans. And I know that that's also, I believe, arguments in lower courts related to, is it Thomas Jefferson High School here locally in the DMV area. So there seems to be some other lower court cases over the same issue. Should we expect, even though we're talking about Harvard and UNC college level, should we expect this type of ruling to also impact, secondary education?
I don't know that they will expressly talk about secondary education, but I'm quite sure that whatever they say in this opinion will have to be taken into account in cases involving high schools and other lower level selective enrollment schools.
Yeah, I'm just covering this. I found it interesting. It's not always that I see, I mean, there's the same issue can be repeated in different courts, but this seems different with, a high school having a case making essentially the same argument of what we're seeing at the Supreme Court. And I don't know, it's very interesting topic to follow. And of course, I like you said, with Justice Jackson's comments and questioning during the Voting Rights Act case this past week, I suspect we'll hear a lot from her in this one as well.
Yes, I'm sure we will in the UNC case, but she won't be speaking during the Harvard case. Right,
yes. And I know one of the other things, is there anything else before I move on, because I know the affirmative action case is really big. Is there anything else that you think we should be looking for, or could this possibly be one where we get multiple kind of a plurality ruling?
It certainly could. We know that we know where many justices fall. We know Justice Alito, Justice Thomas, the Chief Justice are all adamant that race consciousness is unconstitutional. But honestly, I don't know what Justice Barrett thinks. I'm not as confident about what Justice Kavanaugh or Justice Gorsuch, how they would approach this particular issue. So I think I could imagine some separate opinions and no clear majority, but I think the most likely outcome is a determination that race consciousness is unconstitutional, and in the case of Harvard, violates Title VI of the Civil Rights Act.
And then, if that were to be the case, are we going to see what's the domino effect at the college level? Is it less diversity?
Well, there undoubtedly would be some less diversity. I think we would see a lot more colleges trying to find ways to ensure that they have diverse classes without expressly considering race. In Texas, the Fifth Circuit held in the 1990s that race could not be considered in admissions at the University of Texas. That later was changed after the Supreme Court reiterated its position that it could be, but for a number of years in the Fifth Circuit, race could not be considered. And what Texas did is it created something called a top 10% plan, where the top 10% of students at all public high schools in the state automatically could be admitted to the University of Texas, and I believe the flagship school of the University of Texas in Austin. And that helped create a much more diverse class without focusing on race, the race of the applicants. So I think we would see schools experimenting much more with identifying diversity through things like socioeconomic status, perhaps first generation status, education of education or occupation of parents, things like that would lead to more diversity, but across a variety of axes, but aren't explicitly about race.
Mm-hmm. Okay, perfect.
But undoubtedly there would be somewhat less racial diversity, yes.
Right.
Or somewhat, maybe another better way of putting it, there would be fewer members of some minorities at some schools.
And I think this is one of those cases that we probably won't find out exactly what they're going to do until June. the big cases always seem to be at the end.
Yeah, although they're hearing it early enough in the year, they might decide it March or April.
I was going to ask you. So previously, we talked about the Voting Rights Act case, how they didn't issue a stay. They've allowed that map to go forward, and if we should read into that. I guess I wanted to ask you, in terms of a grant they issued this past week, when they took the bench Monday, we get, the first day they're back in session, we get a long orders list. And one of the major cases that they took up is going to be involving Section 230 of the Communications Decency Act. And it's my understanding, I think there's like two cases that are companion cases, and they have to do with families of victims of terrorist attacks. They've sued Google, saying that the company, I think through YouTube, promoted certain content to users that aided terrorist groups in recruitment efforts, that sort of thing. And so I guess the federal law, my understanding, it's been some sort of legal shield for decades for internet companies like Google or these big tech companies. And since the justices have decided to take this case, I'm curious how significant you think that is. Does it suggest that they're going to chip away at Section 230?
I don't know that I can make a prediction about what it suggests. It suggests that four of them think there's an interesting question that requires some attention. And we know that Justice Thomas has said that he's not at all confident that the current scope of immunity as the courts are applying Section 230 is consistent with the text of the statute. So I think it's fair to say that we can predict that Justice Thomas is going to be not particularly sympathetic to the social media companies' claims.
Right.
But I don't know that we can say anything beyond that. It's not that easy to predict based on a grant, especially a grant. I think this case is got enough complications and implications beyond the scope of this particular statute.
Right.
For First Amendment law more generally, I'm not prepared to make a prediction.
It's pretty wild. Just the idea of
when this law was enacted, looking at when the internet came to be and trying to protect like third-party companies, like not having to face defamation lawsuits, and then where we've come with videos, like what's at issue and brought up in some of these cases that they're going to be looking at. It seems like technology moves so much faster than the law. I mean, lightning speed.
Well, certainly in with the internet, and computer and data, things like that, we've seen such massive technological advances in really shockingly short amounts of time. But I think there are likely going to be a lot of arguments about the implications well beyond these particular cases, which have facts that are very sympathetic for the plaintiffs, I think. Texas recently enacted a law that basically prohibits social media companies from moderating, that effectively prohibits them from moderating content. And the Supreme Court actually has stayed that law. I don't think that it's possible to think about the Section 230 questions in isolation from some really big and complicated First Amendment questions.
Mm-hmm. That's definitely one I'm going to be watching. It'd be great. It's just, it's hard to think about not having any sort of protection for these companies or sort of line where they have to can just let anyone post anything. It can't be the Wild West, I guess, on the internet. But
yeah, and part of the issue with these particular cases has to do with the way the algorithms operated to sort of escalate or increase the amount of extreme content that people were being exposed to who were using the platforms. And I think that one of the things that the justices will undoubtedly struggle with to some degree is understanding how these algorithms work and what the implications are for saying to a company, you have to incorporate into your algorithm some way of not sharing content or not pushing content that is likely to lead to, in this case, these terrorist attacks. Mm-hmm.
Yeah, it's going to be one they haven't set the date for oral arguments yet, but I'm very interested to go. It was my first time actually this past week going back into the court since COVID and everything. It was nice to be back there. It's always interesting to see. You can hear on the audio when they live stream, like how the justices are questioning, but it's interesting also to see their faces. So this is definitely one I want to be in the courtroom to see. But I really appreciate you taking time to join us today and to break down these cases. I wanted to ask you about I like to ask former clerks a little bit to bring us inside the court with them. Was there anything like a funny story from your time clerking for Justice Breyer? Any interesting tidbits about him you want to share? Just something for us lay people out here who don't get to go to the Supreme Court all the time. Anything interesting you can share with us?
Well, Justice Breyer was a real pleasure to work for. He was always interested in what his law clerks had to say, and he's one of those people who thinks by talking out loud. Sometimes you do see on the bench, as we were talking about before. But that was great because he would not only be talking to us about the cases that we were working on and that he was thinking about, but because I clerked for him so early in his tenure, it was only his third term on the bench, he was really thinking very deliberately and carefully about how to be a justice. He was trying to think through things like, how do I approach these applications for stays in capital cases, for example. And it was a real privilege to be there for that. He also, I think he stopped doing this a number of years ago, but he used to ride his bike to work. And so he would arrive wearing sort of sweaty clothes and looking, not like one might imagine a Supreme Court justice to look, but and the Supreme Court police, they didn't love the fact that he rode his bike to work.
Oh, I'm sure. And
it made them very nervous.
And nowadays, it seems like there's just so much. I don't know. I worry about like political discourse that I'd worry if he'd be safe, right? Or any of the justices. Sometimes, especially around June.
Yeah, I think there are some new concerns. I think at the time they were more concerned about traffic accidents. He certainly, in my experience, could walk around Washington without being recognized. People would ask him to take their pictures or ask him for directions and would have I was with him when that kind of stuff happened. They would have no idea who he was. And he thought that was funny. He liked that. He liked being a normal person.
Yeah. I wonder now, I think that might change. I don't know, maybe not. He's been on the court. He was on the court for so long that I would think people would recognize him at this point.
I think the average person might recognize his name, but
not face.
I don't know that they could pick him out of a lineup.
Yeah. Well, I really do appreciate you taking time with us to break down these cases and chat about your experience. I'll have to have you back after the affirmative action cases and hear what your thoughts were there.
I'd love to come back. Thanks for inviting me.
Thanks for tuning in to the second episode of Court Watch. I'll have another episode for you next month where we'll break down how the justices were leaning during arguments in the affirmative action cases. If you have not subscribed yet, please do so, and also feel free to email me interesting questions or topics you want explored about the legal reporting world. I'll do my best to answer them during each episode. Thanks for listening, and I look forward to hearing from you all soon. Listen to my podcast, Court Watch, at WashingtonTimes.com or wherever you get your favorite podcasts.